Nigeria is our fatherland, a land blessed with abundant natural and human resources, yet unable to achieve its potential because of corruption. You and I make the change that we desire for our nation. Let's join hands with the EFCC to fight corruption and secure the future prosperity of our country. Hello, and thanks for joining us on another episode of The Eagle. My name is Aisha Muhammad.
Imagine a society where everything works. Durable road networks, stable electricity supply, portable water, well-equipped and functional healthcare facilities, quality education for all, affordable housing schemes, social security benefits, job creation, and a lot more that makes life comfortable to live. That is an ideal society. We can only achieve these if we all play our part. Say no to corruption to enjoy these benefits. Kill corruption to save Nigeria. This message is from the Economic and Financial Crimes Commission, EFCC.
As usual, we shall be bringing updates of activities happening in and around the EFCC with reports of arraignment from the court and a super conviction report of a former governor of Plateau State, Joshua Dariye. Sit back and relax as the program continues right after this timeout. Stay tuned. We start today's episode of The Eagle with a report on the conviction of a former governor of Plateau State, Senator Joshua Dariye, who was sentenced to 14 years imprisonment by a Federal Capital Territory High Court for fraud and diversion of public funds. Rolake Odofinjolayemi has details of what transpired in the court.
Senator Joshua Dariye, a former governor of Plateau State, who was being prosecuted by the EFCC for a 1.16 billion naira fraud, was on June 12, 2018, sentenced to 14 years in prison for criminal breach of trust and 2 years for misappropriation of public funds to run concurrently. Justice Adebukola Banjoku of the Federal Capital Territory High Court, before whom he was standing trial for a 23-count amended charge, found him guilty of 15 of the counts, bordering on criminal breach of trust and misappropriation of public funds, but discharged him on 8. After a judgment that lasted about 8 hours, Justice Banjoku held that, and I quote, "I can't imagine such brazen act. Is it the transfer of as much as about 500 million naira from the state's ecological fund into a personal venture account? There's a litany and trail of woe, which also affects the people of Jos, the beautiful tin city where everybody wanted to be. And to find out that its ecological fund was misappropriated is the shocking aspect. There's a deep sense of irresponsibility. The defendant was in fact richer than his state. This is a trauma of the trial, and there should be no compromise to corruption by whatever shade, color, region, rich or poor. Corruption will forever be corruption. Each case is different on its own, and I have no personal animosity. I'm just doing my job the way I know how to. And not only the ecological funds were misappropriated, but funds from the Plateau State government." Indeed, Dariye, who was first arraigned before the judge on July 13, 2007, had his application to quash the charges dismissed. He proceeded to the Court of Appeal, but failed before proceeding to the Supreme Court, which on February 27, 2015, dismissed his application and reprimanded him, condemning his application as a disservice to the criminal process in Nigeria. The Apex Court also ordered the accelerated hearing of the fraud case against him, thus necessitating the continuation of his trial on January 25, 2016, before Justice Banjoku. Dariye was accused by the EFCC to have diverted about 1.16 billion naira ecological fund meant for the state to his personal use, including transferring monies to Ebenezer Retnan Ventures, an unregistered company managed by him, and Pinnacle Communications Limited. In proving its case against Dariye, the prosecution team led by Rotimi Jacobs SAN called 10 witnesses, including Musa Sunday, the EFCC investigating officer, and Peter Clark, a detective constable with the UK Metropolitan Police in London, who investigated Dariye in the UK for money laundering offences. Presenting several documents in court, including bank documents, the prosecution established that Ebenezer Retnan Ventures was not a registered company, and that its account opening process with then All States Trust Bank was riddled with irregularities indicating dishonest intent for opening the account. The defense team, which was initially led by G.S. Poole SAN, before Kanu Agabi SAN later stepped in at the tail end of the trial, presented 16 witnesses in its defense. In the allocution of the defense, which was made by Paul Erokoro SAN, who stood in for Agabi, he urged the courts to temper justice with mercy, arguing that the bank in question misled the governor into engaging in such practice of private banking. He is actually a victim. Mistakes were made, but my lord should temper justice with mercy. The lawyer that represented him before did not do a particular good job. This man has suffered. End of quote. He argued. He further noted that the prisons are congested and Dariye is a serving senator and that he has served his state. In his counter-argument, Jacobs called on the courts to consider the aggravating factors on the state, arguing that Dariye exploited his position as a public servant and took away government money and misappropriated it. Jacobs further noted, and I quote, "Yes, the prisons are congested, but they are congested with poor people. The big men are not there, and that's why they are congested, because those who are in power and supposed to do something about it have not done anything." End of quote. He further said, "The era of go and sin no more can no longer be done in the new era of the Administration of Criminal Justice Act. A lesson must be told." Jacobs added, and I quote, "He is not my enemy, but people should bear the consequences of their acts. If you can't bear it, then don't do it." End of quote. In addition to the sentencing, Justice Banjoko also ordered that 80 million naira so far recovered by the EFCC be returned to the Plateau State coffers. Rolake Odofinjolaimi, reporting for the Eagle.
Thank you, Rolake, for that report. The witness in the ongoing trial of a former governor of Katsina State, Ibrahim Shehu Shima, has revealed how the ex-governor between 2013 and 2015 approved the expenditure of local government funds without following due process. The witness, Ibrahim Dabo Bujawa, made the disclosure through his statement to the EFCC, which was admitted in evidence and marked as Exhibit 2. Golden Onwura tells us more.
The witness in the statements revealed that his committee on investigation of local government finances at the conclusion of its assignment uncovered series of malpractice. He said, and I quote, "The committee I chaired for the investigation of the finances of local governments and state universal basic education (SUBEB) observed series of malpractice bordering on non-submission of payment vouchers by the Ministry of Local Government and Chieftaincy Affairs, irregular payment of money on sheets of paper, improper and suspected fraudulent payments on the state joint local government account maintained under the Ministry for Local Government and Chieftaincy Affairs, and non-documentation of financial transaction by local governments, all involving the loss of funds to the tune of over 34 billion naira. The witness added that the procedure in which the local government's funds should be disbursed was not followed, and that the way the money was expended was irregular and unlawful. According to him, contrary to the requirement that all members of the Joint Local Government Allocation Committee must meet before local government's funds are disbursed, the committee never met throughout the period under investigation. He further stated that in defiance of the norms, the committee observed that all payments to local government councils were processed through local government and chieftaincy affairs and channeled through ALGON, a non-governmental association which the committee considered unofficial, irregular and unconstitutional. Earlier during the trial, Prosecution Counsel Sam Ologunorisa, SAN, asked the witness if he was given any letter appointing him to chair the Committee on Investigation of Local Government Expenses, to which the witness replied yes. The witness subsequently identified the letter and the prosecution applied to tender same in evidence. The team of counsel representing the accused persons, J.B. Daudu, S.A.N., A.T. Kehinde, S.A.N., B.Y. Kura, S.A.N., and Uyi Iguma objected to the admissibility of the said letter but were all overruled by the court and the letter was admitted as Exhibit 1. Ologunorisa further asked the witness if he could identify the investigation report he conducted during the period, and Bujawa identified it. The document was then requested to be admitted into evidence. Counsel representing the accused persons again objected to the admissibility of the said document. Justice Bako subsequently adjourned the matter to July 9th and 10th for ruling on the admissibility of the investigation report and continuation of trial. It will be recalled that Shema is charged alongside 3 others, Ibrahim Lawa Dankaba, Sani Hamisu Makana, and Ahmed Rufai Safana, for allegedly embezzling over 11 billion naira from the coffers of Katsina State Local Government's joint accounts. Godin Onwura, reporting for The Eagle.
Corruption is dishonesty and illegal behavior by people in positions of trust. A public office is a public trust. Do not abuse positions of trust for private gains. Stay away from corruption. Nigeria is a great nation, and it is our responsibility to make the country greater. If you notice any act of corruption, please report to the EFCC via info@efccnigeria.org or call 09 904 4751 or 09 904 4752. You can also call 09 904 4753. This message is from the Economic and Financial Crimes Commission, EFCC.
The trial of Justice Rita Ofili Ajimogobia and Godwin Obla SAN, which continues with the prosecution witness Olumuyiwa Sholanke, stating that Ofili Ajimogobia lied to the Economic and Financial Crimes Commission EFCC about being sick and on admission at a hospital. The report.
The defendants are being prosecuted on an amended 31-count charge bordering on unlawful enrichment and conspiracy. While Ofili Ajimogobia was alleged to have received a sum of $793,800 in several tranches from different sources between 2012 and 2015, Obla allegedly offered the sum of 5 million naira as gratification to Ofili Ajimogobia so as to pervert the course of justice. The offences are contrary to sections 64 subsection 1, 82A, and 69 subsection 1A of the Criminal Laws of Lagos State, number 11, 2011. At the resumed hearing, Sholanke, medical doctor, Gold Cross Hospital, Ikoyi, Lagos, told the court that he first met the first defendant, Ofili Ajimogobia, on October 7, 2016, when she came to the hospital to complain that she was sick. He further stated that he admitted the first defendant for further medical check so as to know the cause of her illness and also for bed rest. Sholanke said, and I quote, "She was admitted as a private patient in a private ward, as she was accorded the position of a very important person and she was given a VIP procedural treatment." End of quote. Giving further testimony, he told the court that medications were administered on the first defendant, who was also seen by a cardiologist and was discharged on October 13, 2016, with a sick leave paper for a week so that she could rest at home. Led by the prosecution counsel Rotimi Oyedipo, the witness further said that at about 7 p.m. on October 19, 2016, he got a call from the hospital while he was at home that some EFCC operatives were at the hospital. He further explained that not quite long after the call came in from the hospital, he received another call from a senior operative and a lead investigator in the case, Mr. Lawal, saying that they were at the hospital to confirm whether Justice Ajimogobia was on admission or not, and he told him that she had been discharged. Some hours after he spoke with Mr. Lawal on the phone, Justice Ajimogobia called him to say that she was not feeling better, even with her medications. So he told her to go back to the hospital for admission, saying that he would see her the following day. Meanwhile, as at the time Justice Ajumogobia called him, EFCC operatives had already occupied the hospital and were there waiting. During cross-examination by counsel to the first defendant, Wale Akoni, SAN, the witness told the court that he was detained by the commission for one night for what he described as obstruction of justice. He, however, told the court that the commission did not have the intention of detaining him, but it happened because the officer who was supposed to sign his release was not available. The prosecution counsel also submitted that there were records of patients before and after October 19, 2016, the day EFCC operatives allegedly occupied the hospital, and demanded to know whether Ajumogobia was admitted or not. Curiously, the defense counsel told the court that the records for that day did not reflect all the patients who were on admission. He said, and I quote, "My lord, for this reason, it was not shown in the records that my client was on admission, contrary to what the witness said." End of quote. In his response, the witness stated that the only case that was not included in the record list on that day was that of a patient who was brought in the midnight as an emergency case. The prosecution counsel could not close his case owing to the absence of his only remaining witness. He therefore asked the court for another opportunity to bring the last witness to court on the next adjourned date. Also, an application was moved by the counsel to the first defendant, which sought the temporary release of his client's international passport for 4 weeks so as to allow her renew the international passport. Justice Oshodi granted the application on the conditions that the international passport deposited with the Chief Registrar of the court shall be released for 2 weeks, and both the old and the new international passports shall be returned to the Chief Registrar on or before June 25, 2018. Justice Oshodi adjourned the case to September 14, 2018 for continuation of trial. Rolake Odofinjolaimi, reporting for The Eagle.
If you're just joining us, the program is The Eagle, coming to you from the stables of the Economic and Financial Crimes Commission, EFCC. Justice A.R. Muhammad of the Federal High Court sitting in Maitama, Abuja, has adjourned the trial of a former governor of Adamawa State, Ahmad Umar Fintiri, and one other charged with 2.9 billion naira fraud to October 4, 2018. Here are the details.
Fintiri, a former lawmaker who also served briefly as the acting governor of Adamawa State, is being prosecuted on a 5-count charge of bribery and money laundering alongside Mayim Construction and Properties Limited by the Economic and Financial Crimes Commission, EFCC. He was alleged to have defrauded the Adamawa State government by laundering money to the tune of 2.9 billion naira through his naira and dollar account domiciled at EcoBank PLC. The defendant is also accused of making large cash payments for the purchase of landed property in Abuja during the 3 months he held sway as the governor of the state. The matter was adjourned to June 6, 2018 for continuation of cross-examination of the prosecution's first witness, Ibrahim Welye, former secretary to the Adamawa State government, who in an earlier testimony told the court that certain contracts awarded by the former acting governor, including the electrification of Krishinga village in Madagali local government area of the state, had no approval. Welye had in a petition dated May 11, 2015 to the EFCC alleged that the first defendant fraudulently diverted 497 million naira meant for the construction of a lecture theatre for the Faculty of Law, Adamawa State University, MUBI, laying only the foundation but never completing the project. The PW1 maintained his position regarding the content of his petition to the EFCC, saying, and I quote, "I still stand by the content of my petition regarding the renovation of Adamawa State House of Assembly, the construction of Mararaba Gareta to Kamali roads, the construction of road network to Malamri ward in Yola, as well as the reconstruction of 5 roads and stormwater drains in Yola." The witness, however, added that he had no knowledge of any environments granted by the State's House of Assembly in respect of the project. Counsel to the first defendant, Magaji SAN, sought to tender certified true copies of letters of ratification for approval of the Mararaba Garata Kamali road construction dated June 17, 2015 and forwarded to the Honorable Speaker, Adamawa State House of Assembly, a House resolution dated June 17, 2015, a document from the Office of the Honorable Minister of Works captioned Advance Payment Guarantee dated June 9, 2015, addressed to the Director, Sterling Bank PLC Lagos, and a memo in respect of the project addressed to the Governor of Adamawa State through the Secretary to the State Government, signed by one Barrister Yakubu S. Ngbale, Permanent Secretary, Ministry of Works. But ASO Larry Peters, counsel to the EFCC, objected to the tendering of the documents, saying the court had earlier ordered that copies of all documents to be tendered by the defense should be given to the prosecution beforehand. He noted that the documents sought to be tendered were never made available to the prosecution. However, Magaji in response said that indeed the court made an order which has been complied with. He then showed the prosecution a copy of the acknowledgement, following which Peters applied for time to verify service by the defense and was obliged by the court. Thereafter, Magaji presented to the court an application dated May 21st and filed May 25th, 2018, seeking an order granting the first defendant leave to travel to Germany for follow-up medical treatment, and accordingly, the release of his international passports deposited with the court. Peters, while not objecting, said, and I quote, "We have no objection to the application, but we urge your lordship to impose terms and conditions to ensure that the defendant returns back in due time and that the international passports are returned back to the court." End of quote. Justice Mohammed, in granting the application, stated that the conditions imposed on a similar application in September 2017 apply. Rolake Odofinjolaimi, reporting for the Eagle.
Corruption is a cankerworm, na cankerworm. I say na cankerworm, na cankerworm. Corruption don't finish our country. Nigeria women rise up and come together, oh yeah.
Every woman come out, but we fight corruption together, oh. Every woman fall out, but we kill corruption together, oh.
Them they thief our money, send them obodo yibo. Children they suffer every day, better school in no day. Nigeria women come, oh. Women from every sector, make we fight corruption. We won't kill our country. Them go collect money for light, chop the money, light we no see. Good road and good health and call. We no see. I say na cankerworm, oh. Na cankerworm, oh.
Join the EFCC in its crusade to rid Nigeria of corruption. Naija, now we all know.
To be part of this program, you can send your contributions to the Eagle at efccnigeria.org. Next is the arraignment of the Provost of the Federal School of Medical Laboratory Technology, JOS, Sunday Inkeruwem Etukudo, over his complicity in a 4.2 million naira fraud. Earlier slated for June 5, 2018 before Justice D.V. Agishi of the Federal High Court sitting in Jos, Plateau State, was told by the absence of the judge, who was said to be away on another official assignment. Golden Onwura has the details.
Etukudo is to be arraigned alongside Oyibo on a 6-count charge bordering on fraud by the Economic and Financial Crimes Commission, EFCC. The Federal School of Medical Laboratory Provost, in connivance with the desk officer in the Budget Office of the Federation, Lemona Henry Oyibo, allegedly in 2014 obtained money to the tune of 4.2 million naira from the federal government under the pretext of organizing budget preparation training for the account and budget call officers of the FSMLT JOS and converted same to personal use. The offence is in the contravention of Section 8A of the Advanced Fee Fraud and Other Related Offences Act 2006 and punishable under Section 1, subsection 3 of the same Act. Though the parties were in court, the defendants could not take their pleas as the presiding judge was unavoidably absent. In the circumstance, the prosecution and defense counsels Takon Ndifon and Solomon Umo SAN agreed on September 18, 2018 as a date for possible arraignment. Etukudo is currently facing another charge before Justice D.D. Longi of the Plateau State High Court, where he, alongside the accountant FSMLT Yusuf Samuel, the Secretary of Tenders Board FSMLT Ernest Demto, and 2 contractors of FSMLT Goodluck Echewa and Esio Udo, are being prosecuted on a 15-count charge of conspiracy and diversion of funds to the tune of 359 million naira. Golden Omura, reporting for The Eagle.
That's all we have for you on today's episode of The Eagle. You can send your feedback to us via theeagle@efccnigeria.org or search for us on Google Plus at Official EFCC or Official EFCC ng@gmail.com. You can like our page on facebook.com/Official EFCC or follow us on Twitter @Official EFCC. And of course, you can visit our Instagram page. To watch our programs and other activities, log on to youtube.com/Official EFCC. My name is Aisha Mohammed, hoping to see you next week. Do have a good time. Goodbye and God bless Nigeria.
Thank you.